Hey everybody, how's it going? My name is Will and welcome to Copper Jacket TV. So apparently Rob Bonta and the attorneys at the California Department of Justice were so embarrassed by their performance that it gave us another victory at the Ninth Circuit Court of Appeals, and we need to talk about it today because this is a good one. So let's get to it. Now, real quick before we get started, this channel is proudly sponsored by Attorneys on Retainer, who's backed by Attorneys for Freedom, the only law firm in the entire country that does nothing but self-defense cases. So if you're somebody who cares to defend yourself or your loved ones, or maybe you just keep something in your home for your own defense, having that Attorneys on Retainer membership gives you access to an attorney 24/7. So if there's that door kick in at 2 a.m. in the morning and you have to defend yourself in your own home, or you're out walking the streets and you have to defend yourself, you call the number on the back of that card, you speak to an actual attorney giving you instant attorney-client privilege, and they will be there to defend you through the entire process. They even have civil liability coverage, red flag coverage, online education, training, and so much more. So check out this discount code that I have right here. There's a link down below, and with that link, you can save yourself a little bit of money. This is the best peace of mind that you could have in your wallet. Okay, so let's go ahead and talk about what's going on here. So just a couple days ago, I made a video talking about a very important update at the Ninth Circuit Court of Appeals in a case out of the state of California called Nguyen v. Bonta. This is a case that challenged California's 1 in 30 law. It's basically a law that said you can only get one firearm every 30 days. California thinks that they have the power to tell you how many you're allowed to get in a month. So Nguyen v. Bonta is set to overturn that. And after going from court to court and being bounced around, they finally got a decision from a 3-judge panel at the Ninth Circuit. It was a unanimous decision saying that California's law was in fact unconstitutional. It's essentially rights rationing. You're not allowed to ration someone's rights. You can't tell them how often they can have free speech. You can't tell them how often they're allowed to go to church. You can't tell them how often they're allowed to get a firearm. Well, just because we got that win from the 3-judge panel, which was fantastic, it didn't mean that this case was over. The state of California could still ask for an en banc review from the Ninth Circuit, which meant that a larger portion of judges from the Ninth Circuit would essentially rehear this case. And typically for us, that kind of means bad news because the Ninth Circuit typically sides with the state, especially when it goes en banc. Now, the state of California had some time to do that, but instead of filing their en banc petition, they ended up filing for an extension. That extension gave them until yesterday, August 6th of 2025. If they didn't file by that time, then the 3-judge panel's decision held, and that was it. So after refreshing my browser over and over and over yesterday to see if anything new had been filed by California, we just got confirmation this morning from the FPC that California did not file a request for a rehearing en banc. That means that the 3-judge panel's decision saying that California's 1 in 30 law is unconstitutional stands, which is phenomenal news. It's basically a win on top of a win. Because like I was saying before, if this went en banc, we don't know what would have happened. Typically, when a larger portion of the Ninth Circuit hears a case, they tend to side with California, so it wouldn't look very good for us. But now we have that unanimous decision standing at the Ninth Circuit. California's 1 in 30 law is done. Now, even though it's rare and highly unlikely, there is still a nightmare scenario where the court could decide to take this en banc without input from either party. But again, the likelihood of that happening is very low, but it's still best to know about it. We need the court to issue its mandate in this case, which would officially close it. That case would be done. It's over with. It's in the books, right? So we need that to happen. But again, understanding the process and what the Ninth Circuit's all about, sometimes you just need to mention these things. So wanted to make you guys aware of that. Again, it's a win on top of a win. Another major victory in the state of California that knocks down a long-standing regulation. So this is fantastic. It's great news. I wanted to share that with you, and I want to thank you all very much for watching. Y'all have a great day.